All names, places, and institutions are aliases used to protect privacy. Procedures and timelines reflect real-world law and court practice for immersion. The holding cell beneath Riverbend Courthouse smells of industrial cleaner and stale sweat. Defendant Rook sits on a concrete bench, wrists shackled to a steel bar bolted into the cinderblock wall, waiting for the deputies to escort him upstairs to courtroom 3B, where Judge Keystone will decide whether the plea deal he signed 3 months ago, the deal that promised probation, treatment, and a chance to rebuild his life, will hold, or whether the weight of his past will crush that second chance before he ever walks free. His public defender, Attorney North, leans against the opposite wall, reviewing notes on a yellow legal pad, his tie loosened, his face drawn. North has been practicing criminal defense in Granite County for 8 years, long enough to recognize when a case is about to go sideways. And this morning, every instinct he has is screaming that the sentencing hearing upstairs is going to unravel in ways neither he nor his client anticipated. The plea agreement was straightforward on paper. Rook would plead guilty to possession with intent to distribute methamphetamine, a Class B felony, and in exchange for his cooperation and acceptance of responsibility, the state, represented by Prosecutor Slate, would recommend a sentence of 24 months, fully suspended, conditioned on Rook's completion of an intensive outpatient drug treatment program, weekly reporting to a probation officer, random drug testing, and 200 hours of community service. It was the kind of deal that defense attorneys dream about for nonviolent drug offenders, the kind of deal that keeps young men out of overcrowded state prisons and gives them a shot at turning their lives around. But yesterday afternoon, North received a call from Court Administrator Carver, who informed him that the pre-sentence investigation report, prepared by Probation Officer Mercer and submitted to Judge Keystone 2 days prior, contained information that was not disclosed during plea negotiations. Information that could fundamentally alter the sentencing calculus and jeopardize everything North had negotiated for his client. The report, which North requested an emergency copy of and stayed up until 2 in the morning reading, revealed that Rook had 2 prior felony convictions from Kenton County, a jurisdiction 200 miles east of Riverbend. One for aggravated assault stemming from a bar fight 7 years ago, and one for felony possession of a controlled substance from 5 years ago. Neither conviction appeared in the initial discovery provided by Slate's office, and neither was mentioned by Rook during his intake interview with North, or during the plea colloquy in open court. If those priors are accurate, Rook's criminal history score under the state sentencing guidelines jumps from Category 1, reserved for first-time or minimal offenders, to Category 3, which places him in the same tier as repeat violent offenders and career criminals. And if Judge Keystone decides to apply the guidelines strictly, the recommended sentencing range shifts from probation to 6 to 10 years in state prison. North tried to reach Rook last night to ask him directly about the Kenton County convictions, but the jail's phone system was down for maintenance, and by the time he arrived at the courthouse this morning, there was no time for a private consultation before the hearing. So now, in this cramped holding cell beneath the marble corridors and oak-paneled courtrooms of Riverbend Courthouse, North asks the question that will define the next hour of both their lives. Rook, did you have felony convictions in Kenton County that you didn't tell me about? Rook's face goes pale, and he looks down at his shackled hands. I thought those got dismissed, he says quietly. There was a fight, yeah, but I did anger management classes, and they told me if I finished the classes, the charge would go away. And the drug thing, that was just a small amount, personal use, and I went to some diversion thing, and I thought that was done too. I didn't think I had to tell you about stuff that got dismissed. North closes his eyes and takes a slow breath. In that moment, he understands exactly what happened. Rook conflated deferred adjudication and conditional dismissal with expungement, assumed that completing a program meant his record was wiped clean, and never thought to ask for clarification. It is the kind of mistake that defendants make all the time, the kind of mistake that defense attorneys are supposed to catch during intake, and the kind of mistake that can turn a second chance into a decade behind bars. If this story of how one courtroom question can collapse a carefully negotiated plea deal and expose the fragile assumptions underlying the entire criminal justice system has you hooked, make sure you subscribe and drop a comment about what you think should happen next. Because what unfolds upstairs in Judge Keystone's courtroom is a lesson in how sentencing guidelines, judicial discretion, and the duty of candor collide when the truth surfaces too late to save the deal. 3 months earlier, on a humid August morning, Rook had been arrested during a traffic stop on Highway 9, just outside the Riverbend city limits. Deputy Holloway, a 7-year veteran of the Granite County Sheriff's Office, pulled Rook over for a broken taillight and during the course of the stop, claimed to have observed furtive movements, consistent with an attempt to conceal contraband. Holloway asked Rook to step out of the vehicle and consent to a search. Rook, who later told North he was terrified and didn't know he could refuse, agreed. Holloway searched the car and found a small Ziploc bag containing approximately 3 grams of methamphetamine in the glove compartment, along with a digital scale and $40 in cash. Rook was arrested on the spot and charged with possession with intent to distribute. At his initial appearance before Judge Keystone the next day, Rook was appointed North as his public defender. Bail was set at $10,000, an amount Rook's family could not afford, and he was remanded to the Granite County Jail to await trial. Over the next 2 months, North met with Rook 6 times, reviewed the police reports and dashcam footage from the traffic stop, and filed a motion to suppress the evidence on the grounds that the search was not supported by reasonable suspicion and that Rook's consent was coerced. The motion hearing was contentious. Holloway testified that he observed Rook making quick, jerky movements toward the glove compartment after being pulled over, which he interpreted as an attempt to hide drugs or weapons. North cross-examined Holloway aggressively, pointing out inconsistencies between his written report and his testimony, and arguing that Rook's consent was the product of intimidation and Holloway's failure to inform him of his right to refuse. Judge Keystone took the motion under advisement and 2 weeks later denied it, finding that Holloway had reasonable suspicion to ask for consent and that Rook's consent was voluntary. With the evidence intact and trial approaching, North began negotiating with Slate. North's pitch was simple. Rook was a nonviolent offender with minimal criminal history. The amount of drugs recovered was small, and the case was borderline as to whether it met the threshold for intent to distribute versus simple possession. Rook had no prior drug convictions. He had a job at a local warehouse before his arrest. He had family support, and he was willing to plead guilty and engage in treatment. Slate, who had a heavy caseload and limited trial resources, was receptive. After several rounds of negotiation, they agreed to the deal. Guilty plea to possession with intent, recommendation of 24 months, suspended to probation, treatment, and conditions. Rook signed the plea agreement in open court, answering Judge Keystone's questions during the colloquy. Did he understand the charges? Yes. Did he understand the rights he was waiving by pleading guilty? Yes. Did he understand the maximum penalty for the offense? Yes. Was his plea voluntary? Yes. Judge Keystone accepted the plea, ordered a pre-sentence investigation, and scheduled sentencing for 90 days later. North shook Rook's hand and told him he was making the right decision, that if he stayed clean and followed the rules, he'd be home by Christmas. Rook returned to his cell believing he had just been given a second chance. But pre-sentence investigations in Granite County are thorough, and Probation Officer Mercer, a meticulous career civil servant with access to state and interstate criminal databases, pulled records from every jurisdiction where Rook had ever lived. The aggravated assault conviction from Kenton County appeared in a statewide felony database, listed as a conviction from 7 years prior, and the drug possession charge appeared in a separate narcotics offender registry. Mercer included both in the PSI report under the section labeled Criminal History, along with a notation that neither conviction had been disclosed during plea negotiations and that their presence elevated Rook's guideline range significantly. Mercer also included a recommendation. Given the defendant's failure to disclose material criminal history and the seriousness of the prior violent offense, the probation department respectfully recommends a custodial sentence within the applicable guideline range rather than probation. When Slate received a copy of the PSI report, she immediately recognized the problem. She had negotiated the plea deal under the assumption that Rook's criminal history was limited to a single theft conviction, which North had disclosed early in the process. The aggravated assault and the drug felony changed everything. She called North and left a voicemail. "We need to talk about the PSI. There are priors that were not disclosed. The state may need to reconsider its recommendation." North listened to the voicemail 3 times, feeling his stomach drop each time, then requested an emergency copy of the report from the court clerk and began researching Kenton County case records online. Now, as Deputy Crane unlocks the holding cell door and gestures for Rook to stand, North gathers his files and follows his client down the narrow corridor toward the stairwell that leads up to the courtroom. Rook's shackles clink with each step. "What's going to happen up there?" Rook asks, his voice shaking. North wants to reassure him, wants to tell him everything will be fine, but he learned years ago that false hope is crueler than honesty. "The judge is going to ask about the priors," North says. "You need to tell the truth. If you lie, if you try to minimize it or claim you don't remember, she will know, and it will destroy any chance we have of salvaging this. Do you understand?" Rook nods, but his eyes are wet, and North can see the fear radiating off him like heat. They emerge from the stairwell into the second-floor hallway, where morning light streams through tall arched windows overlooking the Riverbend town square. A handful of people wait on benches outside the courtrooms. Defendants in suits borrowed from relatives, attorneys reviewing files, family members clutching tissues. North spots Rook's mother, Mrs. Rook, sitting near the door to courtroom 3B, her face drawn and tired. She waves weakly, and Rook tries to smile but can't quite manage it. Deputy Crane opens the courtroom door, and they step inside. Courtroom 3B is a study in faded grandeur. High ceilings with ornate plasterwork. Oak benches worn smooth by decades of use. Tall windows with heavy curtains pulled back to let in natural light. And a raised bench where Judge Keystone presides, flanked by the state flag and the national flag. The seal of Granite County hangs on the wall behind the bench, a mountain above a river circled by the words, "Justice, Integrity, Service." Prosecutor Slate is already at her table, files stacked neatly, a legal pad open in front of her. Court reporter Weaver sits at her station below the bench, fingers poised above the stenotype machine. A handful of spectators occupy the gallery. Mrs. Rook in the second row, two courthouse regulars who attend every sentencing hearing, a law student with a laptop, and a reporter from the Riverbend Gazette named Finch, who covers criminal justice issues and has been following the spike in drug prosecutions in Granite County over the past year. Deputy Crane escorts Rook to the defense table and removes his shackles, then takes a position near the side door. North sets his briefcase down, pulls out his notes, and waits. At exactly 9 o'clock, the bailiff calls, "All rise," and Judge Keystone enters through the door behind the bench. She is in her mid-50s, with silver hair pulled back in a bun, black robes, and an expression that reveals nothing. She takes her seat and says, "Please be seated. Court reporter Weaver, please note that we are on the record in the matter of State v. Rook, case number 24, CR 1138, sentencing hearing. Counsel, please state your appearances." Slate stands. "Prosecutor Elaine Slate for the state, Your Honor." North stands. "Defense Attorney James North for the defendant, who is present in court." Judge Keystone nods and opens the file in front of her. For a long moment she reads in silence, flipping through pages, making notes in the margins. The courtroom is utterly quiet, except for the faint hum of the ventilation system and the soft tapping of Weaver's stenotype machine. Finally, Judge Keystone looks up and removes her reading glasses. "Counsel," she says, her voice calm but edged with something North cannot quite identify. "Before we proceed to sentencing, I need to address a significant discrepancy between the plea agreement and the presentence investigation report prepared by Probation Officer Mercer. The plea agreement, which was negotiated by counsel and accepted by this court 3 months ago, recommended a sentence of 24 months, fully suspended to probation, based on what I understood at the time to be a defendant with minimal criminal history. However, the PSI report indicates that Mr. Rook has 2 prior felony convictions from Kenton County, one for aggravated assault and one for felony possession of a controlled substance. Neither of these convictions was mentioned during the plea colloquy, and neither appears in any of the filings submitted by defense counsel or the state. Mr. North, were you aware of these prior convictions when you negotiated the plea agreement?" The question hangs in the air like a blade. North stands and steps to the podium, his mouth dry. "Your Honor, I was not aware of those convictions. My client disclosed a prior theft conviction during our initial intake, and that information was provided to the state and reflected in the plea colloquy. The Kenton County convictions were not disclosed to me by my client, and they did not appear in the initial discovery provided by the state. I learned of their existence only yesterday when I received a copy of the PSI report." Judge Keystone turns to Slate. "Ms. Slate, was the state aware of these prior convictions during plea negotiations?" Slate stands. "No, Your Honor. The state's initial background check revealed only the theft conviction disclosed by defense counsel. The Kenton County convictions did not appear in the databases we routinely consult during plea negotiations. It was only when Probation Officer Mercer conducted a more exhaustive search for the PSI that these records surfaced. The state relied on the defendant's representations and the defense's disclosures when agreeing to recommend probation. Judge Keystone nods slowly, her gaze moving from Slate to North to Rook. "Mr. Rook," she says, addressing the defendant directly, "please stand." Rook rises, his chair scraping against the tile floor. His hands tremble. "Mr. Rook, during the plea colloquy 3 months ago, I asked you whether you understood the charges against you and whether you were entering your plea voluntarily and with full knowledge of the consequences. You answered yes to both questions. I also asked whether there was anything else this court should know before accepting your plea. You said no. Did you knowingly fail to disclose prior felony convictions to your attorney, to the prosecutor, or to this court?" Rook's voice is barely above a whisper. "Your Honor, I didn't think those convictions counted. The assault charge in Kenton County. I got into a fight at a bar and they arrested me. And my lawyer there said if I completed an anger management program, the charge would be dismissed. I did the program, or most of it, and then I moved back to Riverbend, and I never heard anything else about it. I thought it went away. And the drug charge, that was just a small amount for personal use. And they put me in some kind of diversion program, and I went to a few meetings, and then I moved, and I thought that was done too. I didn't know I still had felony convictions on my record. I'm not lying, Your Honor. I really didn't know." Judge Keystone writes something on her legal pad, then looks up. "Mr. Rook, a felony conviction does not simply go away because you moved or because you completed part of a program. If you pled guilty or were found guilty, that conviction remains part of your criminal record unless it is formally expunged by court order. Deferred adjudication and diversion programs can result in dismissals, but only if you complete all required conditions, and even then, the records remain unless expunged. The fact that you did not fully understand the legal status of your prior charges does not change the fact that you had a duty to disclose them during the plea process." She turns back to North. "Mr. North, did you ask your client during intake whether he had any prior arrests, charges, or convictions?" North's throat tightens. "Yes, Your Honor. I asked him specifically whether he had any prior criminal history, and he disclosed the theft conviction. I asked whether there were any other charges or convictions, and he said no. I relied on that representation." Judge Keystone looks at Slate. "Ms. Slate, does the state wish to move to vacate the plea agreement on the grounds of material misrepresentation? This is the moment. If Slate moves to vacate, Rook will be back at square one, facing trial on a Class B felony with no deal, no probation recommendation, and a prosecutor who now views him as dishonest. If Slate does not move to vacate, but instead asks for an upward departure, Judge Keystone has wide discretion to impose a sentence far harsher than the 24 months suspended." Slate considers for a moment, then says, "Your Honor, the state does not move to vacate the plea at this time. The defendant did enter a knowing and voluntary plea to the charge, and there is no evidence that he intended to deceive the court. However, the state does request that the court consider the full criminal history as outlined in the PSI report and exercise its discretion independent of the joint recommendation. Under the sentencing guidelines, with 2 prior felonies, one of which involved violence, Mr. Rook's criminal history score is Category 3, and the applicable guideline range for this offense is 6 to 10 years in the custody of the State Department of Corrections. Given the seriousness of the underlying offense and the defendant's failure to disclose material information, the state recommends a sentence of 8 years, with eligibility for parole after serving 50%. The words land like a sledgehammer. Mrs. Rook gasps audibly from the gallery. Rook sinks into his chair, face buried in his hands. North feels his stomach twist. 8 years. 4 times the original recommendation. Judge Keystone writes for a moment, then says, "Mr. North, do you wish to be heard?" North forces himself to focus. "Your Honor, the state's recommendation is grossly disproportionate to the conduct at issue and ignores the substantial mitigating factors in this case. This was a nonviolent drug offense. The quantity of methamphetamine recovered was minimal and consistent with low-level distribution, not large-scale trafficking. Mr. Rook has no prior drug trafficking convictions. The prior convictions in Kenton County, while serious, occurred 7 and 5 years ago, respectively, and there is no evidence of escalating violence or criminal behavior since that time. Mr. Rook has stable housing with his mother, a job offer contingent on his release, and family support. He has expressed genuine remorse and a willingness to engage in treatment. An 8-year sentence would be devastating and would foreclose any meaningful opportunity for rehabilitation. The spirit of the original plea agreement was to provide Mr. Rook with an opportunity to address his substance abuse issues and reintegrate into the community. We respectfully ask the court to honor that spirit and impose a sentence of no more than 3 years, with credit for time served and early release conditioned on successful completion of programming. Judge Keystone listens, her expression unreadable. When North finishes, she turns to Rook. Mr. Rook, you have the right to allocution, to speak on your own behalf before I impose sentence. Do you wish to make a statement? Rook stands, his voice hoarse but steady. Your Honor, I know I messed up. I should have been clearer about my past. I should have asked more questions, brought paperwork, done something to make sure you knew everything. I was scared that if I told Mr. North about the assault and the other charge, he wouldn't take my case, or you wouldn't give me a chance. I know that was wrong, but I swear to you, I'm not a bad person. I got into some bad situations when I was younger, and I've been trying to get my life together ever since. My mom's here. She's been supporting me, helping me stay clean, and I have a job lined up if I can get out. I'm asking you, please, give me that second chance. I know I don't deserve it after what happened, but I'm begging you. I can't do 10 years. I won't survive it. His voice cracks, and he sits down, wiping his eyes. Judge Keystone sets her pen down and folds her hands on the bench. Mr. Rook, I have presided over this court for 12 years. In that time, I have sentenced hundreds of defendants. I have seen every kind of case: violent offenders, white-collar criminals, addicts, traffickers, people who made one terrible mistake, and people who have cycled through the system their entire adult lives. I take sentencing seriously. It is the most solemn duty I have, because the decisions I make in this courtroom shape lives, families, and communities. When a defendant comes before me, accepts responsibility, shows genuine remorse, and demonstrates a commitment to change, I have discretion to show mercy. I can depart downward from the guidelines. I can suspend sentences. I can craft conditions that prioritize rehabilitation over incarceration. But all of that depends on trust. It depends on the defendant being honest with his attorney, honest with the prosecutor, and honest with this court. You were not fully honest, Mr. Rook. You withheld information that was material to the plea negotiations and to my evaluation of your character and risk to the community. You stood in this courtroom 3 months ago, under oath, and when I asked if there was anything else I should know, you said no. I am willing to accept that you did not act with malicious intent, that your failure to disclose was the product of confusion and fear rather than deliberate deceit. But intent does not erase consequence. The plea agreement was built on incomplete information, and I cannot ignore that. At the same time, I am not persuaded that an 8-year sentence is appropriate for the conduct at issue. You were arrested with a small quantity of methamphetamine. You were not armed. You did not resist arrest. The prior convictions, while serious, are not recent, and there is no evidence of escalating violence. However, your criminal history score under the guidelines places you in Category 3, and the guidelines reflect this jurisdiction's considered judgment about proportionality and deterrence. I am going to impose a sentence that holds you accountable while also recognizing the mitigating factors Mr. North has raised. On the charge of possession with intent to distribute a controlled substance, I sentence you to 10 years in the custody of the State Department of Corrections. However, I am suspending 4 years of that sentence, conditioned on your successful completion of the first 6 years without disciplinary infractions and your participation in all available substance abuse and vocational programming. You will serve 6 years in custody and will be eligible for parole after serving 60% of the active sentence. Upon release, you will be subject to 4 years of supervised probation with conditions including drug testing, employment, community service, and regular reporting. If you violate probation, the suspended 4 years will be activated, and you will serve the full 10 years. This sentence is within the guideline range and reflects both the seriousness of your conduct and the need for accountability. She strikes her gavel once. Anything further from counsel? North's mind races. 6 years active, 4 suspended. It is not 8, but it is not probation. It is not the second chance his client was promised. Your Honor, he says, his voice tight, I would ask the court to consider a further downward departure based on Mr. Rook's willingness to engage in treatment and his lack of violent conduct in this case. 6 years in custody is... Judge Keystone cuts him off gently but firmly. Counselor, I have considered all mitigating factors raised in your memorandum and during allocution. My sentence is within the guideline range and is supported by the record. If you believe the sentence is excessive, you may note your objection and pursue an appeal. North hesitates, then says, the defense objects to the sentence as excessive and respectfully requests that the court's full findings and reasoning be stated on the record for purposes of appellate review. So noted, Judge Keystone says. Court reporter Weaver will ensure the record is complete. Ms. Slate, anything from the state? Nothing further, Your Honor. Mr. Rook, you will be remanded to the custody of the Granite County Sheriff pending transfer to state intake. You have the right to appeal this sentence within 30 days. Your attorney will explain the process. This court is adjourned. Judge Keystone rises. The bailiff calls, all rise. Rook does not move. 2 deputies approach, and North steps aside as they place handcuffs on his client. Mrs. Rook is crying, reaching toward her son. Rook looks back at her, mouthing, I'm sorry, as the deputies lead him toward the holding cell door. North watches, frozen, knowing that in moments, his client will be back in a cell. And the next conversation they have will be about appeals, about survival, about 6 years that were supposed to be probation. Over the next week, North does what defense attorneys do when a sentencing collapses. He dissects every line of the record. He orders the full transcript from Weaver, pays the expedited fee, and reviews the plea colloquy word by word. He finds no perjury, no moment where Rook was directly asked about Kenton County convictions, and lied. The colloquy was brief, focused on the elements of the offense. No one asked the right follow-up questions. The PSI was completed after the plea, standard practice in Granite County, which meant the priors surfaced too late to inform negotiations. North pulls the sentencing guidelines manual and runs the numbers. Possession with intent, base offense level 4. 2 prior felonies, 1 violent, category 3 criminal history. Guideline range 6 to 10 years. Judge Keystone imposed 6 active, 4 suspended, functionally 10 years total, bottom of the range. An appellate court reviewing for abuse of discretion will see a guideline-compliant sentence supported by findings on the record. There is no legal error. The only argument is substantive unreasonableness, but that is an uphill battle when the defendant's lack of candor undermined the original deal. North visits Rook at the jail and explains this through glass. So there's no appeal? Rook asks, his voice hollow. There's always an appeal, North says, but the chances are slim. The judge followed the law. The sentence is within range. The better strategy is to focus on programming, parole preparation, and making the case in 6 years that you've changed. But 3 months later, something shifts. Attorney Calloway from the State Public Defender's Appellate Division calls North. She's been reviewing Rook's case as part of a post-conviction audit and found a discrepancy. The aggravated assault listed in the PSI as a felony conviction was actually reduced to a misdemeanor as part of a deferred adjudication agreement. Rook completed the anger management program, contrary to what he told Judge Keystone, and the felony was never formally entered. The records were misfiled in the database Mercer used. If that conviction is removed, Rook's criminal history drops from Category 3 to Category 2, shifting the guideline range from 6 to 10 years down to 3 to 6. Suddenly, the 6-year active sentence is at the top of the range, and the 10-year total exceeds it. Calloway digs deeper and discovers the drug possession charge was also expunged after Rook completed a diversion program. Neither conviction should have counted. Rook's actual criminal history is Category 1, 1 theft conviction. The correct guideline range is 2 to 4 years. Judge Keystone's 10-year sentence is more than double the top of the correct range. Calloway files a motion for correction of sentence. The hearing is scheduled for early spring. Rook is transported back to Riverbend Courthouse. He sits at the defense table in a jumpsuit, flanked by North and Calloway. Judge Keystone presides. Slate opposes the motion, but when Calloway presents certified records, deferred adjudication agreements, completion certificates, expungement orders, the evidence is undeniable. Judge Keystone asks Slate whether she can provide a legal basis to impose 10 years if the criminal history is Category 1. Slate concedes she cannot. Judge Keystone turns to Rook and asks directly whether he lied or genuinely believed the charges were dismissed. Rook's voice is steady. I thought they were gone. I did the programs, I got letters. I didn't know they were still there. Judge Keystone reviews the corrected records and vacates the original sentence. She imposes a new sentence: 4 years in custody, credit for 1 year served, parole eligibility at 50% of the remaining term, 18 months from today. The 4-year suspended portion is vacated. Rook's total exposure drops from 10 years to 4, his remaining time from 5 years to 18 months. Mrs. Rook weeps in the gallery, this time in relief. But the system's fractures remain visible. Rook will serve 2.5 years total for a nonviolent drug offense because of database errors, intake confusion, and a process that assumed accuracy in records that were incomplete. Probation Officer Mercer faces no discipline. The State Office of Court Administration issues a memo about verifying expungements, but conducts no audit of past cases. North commits to independently verifying every client's criminal history going forward, but knows most defendants cannot afford that level of scrutiny. Slate begins flagging PSI discrepancies internally, aware that integrity depends on accurate foundations. Judge Keystone adds a new question to every plea colloquy. Have you reviewed your full criminal history with your attorney, including dismissed, reduced, or expunged charges, to ensure this court has complete information? It is a small reform, born from one case, but it matters. The courtroom at day's end is silent except for the hum of HVAC and the rustle of papers as Weaver packs her equipment. North stands alone at the defense table, thinking about the distance between what the law promises, fairness, proportionality, second chances, and what it delivers when information is incomplete, databases wrong, defendants confused. Rook will serve 18 more months not because he was dangerous or unrepentant, but because the machinery of justice depends on fragile inputs. Clerks entering data, defendants understanding questions, lawyers asking follow-ups, judges trusting reports. The plea deal that promised a second chance became a decade in prison, then corrected to something closer to just, but only because someone caught the error and fought to fix it. How many others are serving sentences based on wrong information? And how many will never have an appellate attorney review their case? Or a defender with time to chase records across counties? Or a judge willing to revisit a sentence after the gavel falls? North closes his briefcase and walks toward the exit. Late afternoon sun streaming through tall courthouse windows, illuminating marble floors and brass plaques. If this look inside how procedure and human error collide has changed how you think about plea deals and second chances, drop a comment on what reforms matter most, and subscribe for more stories that show the criminal justice system as it really is. Complicated, fallible, and always more than the headlines suggest.